Oh God. I think it's recording, ladies. I'm not. Yeah, it says it's recording. Okay.
So yes, well, if all my changes were accepted,
If they were,
then you'd have a clean version.
I'm pretty sure Simon accepted most of your changes. He told me that he's done it.
Okay.
Because, I mean, I did because you're the expert, not me. So, and I think Simon was of the same opinion. Shall we make a start on some property? Meaning of property is the first chapter. I don't know. We'll sort of have a look at this. There's immovables first, yeah, because I'm more comfortable with it. I think really we've got to do immovables before we do conveyancing, really, because we can't really do conveyancing unless we do immovables first. So we'll try and get this done by, I don't know whether we'll get it done by lunchtime, but we'll certainly try and get it done. There's some introductory material there on feudalism, etc., which I think I'm going to show off. I don't you can read it through and I think forget about it. Would you agree with me there, John?
Well, I commented to I hope she wasn't going to start going into this in any text in terms of reading, which I literally never read any of that.
What? No.
And I can
you have read Gordon Dawes.
I've never read Gordon
Dawes. Oh, I have read Gordon's book, and I have read Maitland, but anyway, it doesn't matter.
You read
it all? Dawes? No, I've only read the property bit. Oh no, I don't like anything other than property law. So I did read Dawes's stuff. I did buy a copy and read it on all the property chapters and anything that was anything. Yes, it's some of it's out of date. That's the big problem with it, But yeah, it's a grand work. But anyway, yes, I did read that. No, I didn't expect. I've put them in there, but I don't think I expect people necessarily to read. To be perfectly frank, ladies, I think as long as you get through the guide, that's what you need. And I think we had a little bit of this conversation last week. And again, with the cases, I mean, I will have a look at the Vaudan case with you in a moment. But I don't think you need to, I don't know what John thinks about this, but I don't think you need to go off and read these cases. I did go off and read Vaudan incidentally, but
Odin and Hamlet is incredibly useful. However, it is not easy reading.
No, it's not easy.
Also, I would tend to advise, don't just read the Privy Council case, which is the one given here. It's the primary case, of course, but the case was fascinating because it spanned a period of something like, I think, 10 years even, bouncing back between the Seneschal's Court, the Royal Court, the Appeal Court, the Privy Council, back to the Seneschal's Court, the Royal Court, the Appeal Court. The Channel Islands, or the Guernsey Appeal Court decision, which is after the Privy Council one, is worth reading because it revisits the concept of the meaning of bon foi, which was added to the legislation in 1909. And the court gave a decision on what it felt was meant by those words. Of course, with the hierarchy of court decisions, one tends to have to sort of think, okay, well, if the council didn't say that, it was only the appeal court. But it's a very good analysis. And I like to say, although I've never had the chance to put this before the Royal Court, I like to say that the analysis in that underpins, if you like, the reason why we do not have the issues with adverse possession that English law has.
In what sense?
Whilst Guernsey law, the ownership of immovables in Guernsey law is based on possession.
Yeah.
The Privy Council tried to explain that the addition of the words en bon foi weren't introducing anything new, it was always there. But the requirement of good faith means that if you claim possession of land, in particular, if you actually undertake the acts necessary to evidence possession, so you take possession of the land, you demand the rents from those in occupation, you cut the hedges, you do whatever is necessary to show that you're the owner. You do so because you had every reason to suppose that you were the true owner. It's not about marching in and saying, well, there's no one else around, this is mine.
In the same way that
In the same way that English law went down that road
Yeah.
for adverse possession, and look at the problems it's given them. So that's why
I thought that concept doesn't exist in the French. That you can't, once title is divested in you, that nobody else can come along and claim it unless you give it to them. Yeah.
That is correct.
Yeah.
The point is that you always have an area of land, little bits of land where.
Yeah, like the wall, little bit, that bit out by
Cobo.
yeah.
Oh, yeah.
Yeah, that's causing problems.
We're still waiting eagerly on Sir Richard Politics. I don't envy him because he has got an absolute monster try and issue judgment on.
Which will be appealed presumably by one of the sides.
Mr. Holroyd has looks deep enough to appeal. However,
When do you, I can't remember the cut-off date is for judgment for this sort of
well, put it this way, we were acting for the Catholic Constable.
When's it out here?
So the hearing was early January.
Okay, so it'll be a while.
Yeah.
Well, anytime. March.
With the Crown intervening. So there were some very odd arguments being put up. Indeed. The Crown. And Mr. Holroyd's arguments as well were based 100% on English law. Nick Barnes didn't quote a single Guernsey authority.
Can't see the DB. Oh no, it's not the
It's bailiff.
bailiff, sorry, but even the bailiff really.
I don't think
Like,
that's you
that
can
was-
vote.
that's why that, no. It's near where the pub is opposite.
Yeah.
On the corner, that bit there, the wasteland there.
Yeah. So Mr. Holroyd is claiming that he's the owner on the basis of a conveyance that was registered about 2003, where the Dame of Puffray, who I think is his mother, no nepotism there, conveyed the land to him, but without any guarantee of title. Now, my argument was based on Terrier, which was that where in Normandy, where land is saved from sea, or in fact saved generally, in other words, reclaimed, the owner of the adjoining land, within the period laid down for prescription, so it would have originally been 40 years, would become the owner of that land upon making an aveu to the seigneur at the next sitting of the Court of Chief Pleas of the Fief. So he would go along to the seigneur and say, this land has been saved from the sea. I am the owner of the adjoining land. It measures X purchase. The due payable to you as seigneur because it's recovered from the foreshore which belongs to you. The due payable to you is so many tournois. Here is my due title. That's how title would have been given to him.
If he decides that case, I think when it happens, is that going to change what we will be learning? Arguably, no. It's not going to impact what we need.
No. It was, that was an argument all about possession, how to prove possession, what evidence is possession. And the title documents to the adjoining supermarket were claiming ownership of that land from at least 1874, if not prior.
Down the road?
The supermarket that uses it as a car park
Oh, I'm thinking
It's
of a
tighter.
different land. I'm thinking of the wasteland that's sort of opposite. On the corner. On the corner. So you know, opposite the rock mount, but opposite on the roadside where the road is, there's that bit of land there's nothing on it.
Opposite the rock.
No, it's not opposite, but if you're coming up to the filter and then you turn right to the rock mount, on the left-hand corner there. Is that
Yeah,
what
that's
you're
what I thought that, yeah. That was the sort of land I'm thinking of as in terms of adverse possession.
opposite where people parked, walked?
Oh, no, that's private land.
Oh, okay. Well, actually, you walked over it, there's nothing there. I just assumed that was wasteland. So where's this piece
There's
of
no
land that you're
coastal
talking
wasteland
about?
anyway, anywhere, isn't there
No,
really?
no.
No sort of,
No.
that sort of isn't a concept.
Yeah.
Yeah.
Okay.
Um,
I'm just trying to think where we may come back to that.
yeah, we'll come back to Vildan time and time again, I think.
Yeah,
throughout.
it's a very important case.
Yes, it is.
Do read that.
And yes, I was going to say, I would, sorry, beg your pardon.
Read the one that's here, the appeal.
Yeah, we do.
We'll read the appeal and then go back, but I would, I think that's one of the few cases that I would advise you to actually read out. It isn't, I mean, I agree with you, it's not easy reading, but
Is that when you go and see people?
Yes.
Oh.
If it isn't, it is actually found. It was of such importance. It's published in, don't ask me which volume, but it's the 1974 volume of Auditing Council. The actual laws. Yeah.
okay. Well, let me know if you can't find that anywhere. So if it's not, you think it's on the Jersey, Guernsey, I beg your
I
pardon.
think it is, but it's not easy to find stuff on there.
Quite where it would be in the Guernsey Legal Resources.
I don't know.
Not quite.
I didn't find it there. I went to the
Pre-2000.
Yeah, it's again, you may not see them. Of course, I grew up with published volumes of Guernsey law, so the Orders and Council bought them. If you go into the wrote-down series of Orders and Council in the 1974 year, whichever period that falls in, you will find the entire Bowden and Hammond case printed in there. The Royal Court ordered that it be put in there.
I think you might be able to.
Yeah.
Wait a second, folks, because you might just be able to Google this thing, if that makes sense. I don't know. Does that make sense? I actually went to the but I do think it's an important case.
It should be. I would never rely on that as being important. I used to.
That's the sunshine. Just beautiful. That's, no.
I've got all, certainly these cases, Kerry Olsen holds them in its own database. So I can just ping.
Wait a minute, you can Google it. Oh, wait a minute, it hasn't got the full judgment, only the headnote.
That would be really helpful.
Yeah, sorry. Yeah.
Yeah, that's fine. So I'll need your email addresses at some point. But
Yeah.
Yeah, so the only thing I was going to suggest was I was going to try next time I'm in Jersey to scan it, if that makes sense, and then put it up on the VLE, but I'm not sure. I think I'd rather John do it, I think.
I've got it as a PDF.
Oh.
I've got it in paper.
Thank you.
Thank you. What else do we need to know from this? Okay, so have a read of that. Tease out the points of law from that and tease out what has been said. Oh, there's I don't know, we did this last week, this division into movables and immovables, etc., and the importance of this. I don't know really what I've got to say on this. I did sort of do a little drawing about movables and immovables, but I don't know whether you really need this and whether they really need something like that. Are they?
Not down to that level of granular detail.
No, no, I don't think so. I mean, we looked at this last week, the importance of movables and immovables, so I'm not sure I want to sort of harp on about it again. And the only thing I would say is that can we please, the 1 or 2 points we do want to make.
What page are we on?
I'm just talking, I think,
Oh,
generally.
sorry.
So we're on page 4, 1.4. Yeah. I think probably leases ought to be mentioned because leases comprise movables in Guernsey law. To be perfectly frank, I don't think that's that far out of sync with the history of English law, incidentally, where they were classed as personalty historically. So I don't think that's that bizarre, but they're classed as movables rather than immovables. Also, rent, in the English sense of the word rent, is also movable. I think that probably, that to me is common sense. I thought it was movable rather than immovable. And the only other thing that I've put down here that you probably need to know is that we've got, I've divided immovables up. I don't think I'm going to get anything on this. I've divided them up into par la nature et par destination, which is really the French division of immovables. And it is in the notes, but I don't think anything really hangs on that, I suppose. I don't know whether you agree with me on that. You know, I mean,
I agree. I mean, key is always when you're in an examination and you're trying to think, okay, so this is all about movables. Clues in the word, immovable, land. You start from land, movable, everything else. Now, can anything become immovable, even though it started out as being movable? Yes. A house. So the bricks that made the house, once they're attached to the land, they're land. And then we've got all these other fine distinctions about trees and growing crops. Don't worry about that. You're not going to get examined on that.
No, I can't. I can't see.
I mean, that's presumably right.
Mainly,
Yeah, but it could still be relevant, couldn't it? I mean, like, you're the conveyancer, not me.
it's relevant only. I won't say that because actually it would be an absolute cracking question, or at least possibly a bit evil.
Yeah, no, let's not go there.
Not there.
In terms of that, it would be an evil.
Yeah.
Not that you shouldn't tell everyone. So basically,
No, so, I mean, there are some.
Do you not sort of, again, you know, I don't know local conditions, but would you not, for example, sell a field of standing, I can't say standing straw, which would be selling the movable? Does that make sense? I don't know, would you do that in Guernsey? Because we would in England, we'd sell a field of standing straw. You're not selling the field, you're selling the straw on the field, if that makes sense.
If you were to, the very moment of the straw became removable.
Yes, but we would sell it and then let somebody cut it, if that makes sense.
Oh, that's different. So in Guernsey law, the moment you cut it, it is detached from the land, it has become a movable thing.
Are you selling movables or immovables? Immovables.
So when you're selling the immovable, which is the field, the straw is no longer part of it. And in fact, I had that only a couple of years ago, and
That's if it's being cut away.
my client was buying some fields, and he and I turned up to have a look at the fields. They were, I mean, he bought them for his horses, so it cost $350,000 to buy some fields for his horses. He's a hedge fund manager. Anyway, we turned up, and there were all these massive straw bales. And he said to me, "Oh, do I get those?" And I said, "Oh, no, we're going to have to make sure that we understand who's getting those."
Yeah.
and it turned out the tenant farmer who was vacating the fields was going to take them with him. Fair enough. That was the law. There's nothing I could do about it.
Well, that's all makes logical sense, 'cause it's not.
Correct.
Yeah, that's what
So
it
there
does,
is,
yeah.
there is, so Guernsey law is like civil law. It's really quite-
Yeah.
So if you've got rose bushes growing in the garden, the vendor can't walk off with them. If they're in a pot, then you can just pick the pot out. No problem.
So in that sense with the straw, if the straw's not cut at the time that you are purchasing the field,
It's
it
yours.
would be
But can-
immovable.
Correct.
Whereas if it had been cut in your example.
Can I just ask you, John, can you not sell, because in England we do, I agree with, I mean, that makes sense to me, but in England you would actually sell not the field, you'd sell the standing straw in the field and let a contractor or something come in and cut it. You can't do that in Guernsey.
Well, that would just be a pattern.
Yes, that's right, it is, yes, it is a personal, yes, it's nothing to do with, I mean, it's sort of,
Not
it's
interesting,
a
Mark.
contract for movables, basically, yes, yeah, and you can do that.
Yeah.
Yeah,
So,
okay.
I'll give an example. If I was doing that, one of the things I'd be asking the owner of the field is, okay, we're letting the field. Can you tell me the terms on which the farmer or user of the field is allowed to take the produce of the field? What's he allowed to do with it, in other words? Can he merely graze? Can he plant crops and harvest them? Because we need to spell this out to avoid all these issues.
Yeah, okay. Movables, I think, I could be wrong, I think that's probably,
You put about Kunja,
well, contract, yeah, why did I do that? I've got no idea why I did that. There you go, yeah. Senior moment, lots of those these days. Okay, oh, the two culture, yes, what does it mean? Yes.
Well, quick bit of translation. What does the word Kunja actually mean?
I also it's in permission to sell.
Transfer,
Yes.
sale, transfer.
Yeah.
I bet the best word the best description I've heard of it is release.
Ah, yes.
It's a release.
Yes.
I give my contract my release.
Again, yeah, again, I'm not sure you desperately need that, ladies, because it's historical import only.
Certainly in terms of Guernsey conveyancing, it's now been of no relevance since 2003. So
Why is it 2003?
because that was when the law finally took effect and congé was abolished.
Oh, yes. Sorry.
Yeah. I think it does say something in the notes.
So we've actually written it in the notes.
Yeah.
I don't know whether you've got anything to say on meaning of property, other than property.
So,
There's a lot of history there, which
well, the problem is, well, the English law is not hugely different in that regard, in that you have to learn history to understand why English land law looks like it does.
I agree with you.
It's a
And
history lesson.
yeah, and I think because I'm a great believer in that you've got to know the history of particularly land more than any other subject, I must confess, in order to understand it. And the trouble is, these days in English land law, people don't teach the history, and therefore students sort of sit there and go, "Well, I don't understand this, I don't understand that." I think, well, yes, if we've gone back 500 years, you would understand that. And so that's why I tend to put history in. But, okay, we're on to our co-ownership. Délaissance, partage and licitation, sorry, I left it with there. Which these do come up on the paper quite regularly, don't they? Yes, they are very important. Now, I don't know how we want to do this, I don't know whether you want to talk about this or whether we want to have a look at a problem question, which should cover a lot of the points. It's completely up to you. Now, look at the Mary question, if you like. Sorry, I don't like sort of force. Okay. Let's have a look at the problem question, which hopefully will cover most of the points, not all, most of the points in these chapters. Mary wanted to provide for her son Fred This is worksheet 2, question 1. Okay. It's a fairly straightforward question. Wants to provide for son, Fred, wants to give him a property to live in, but she can't afford to purchase a house in his name. Therefore, she purchases the house with Fred, which is conveyed to them as joint owners for the 5 of them and heirs of such survivor. Mary provided entire purchase price and both lived in the property. Oh yeah, Zelda the lap dancer's again with us this week. Last year, Fred formed an attachment with Zelda the lap dancer, of whom Mary disapproves. Fred wishes Zelda to move in with them, and Mary is unhappy. She wishes to know whether she can bring the arrangement to an end, and if so, what interest she will have in the property. Discuss reference to case law, and then we can look together based on what's she going to say about that, ladies? Please.
So, no longer held in joint will.
All right, I'd probably go back. I must think I agree with you. Sorry, there is a French math in this. I'd go back and go back to basics and say, well, this is a question about co-ownership. And there are 2 different kinds of co-ownership. So let's put a structure on this so that we're looking to see. I mean, it's pretty obvious which sort of co-ownership this is, because the question tells us. But I think we ought to sort of mention that 2 types of ownership: the joint ownership and the ownership in common. And to be perfectly frank, we don't have to really work out which one's which, because we are told. Would you all agree with that? Okay. So we know that it's that they are joint owners. In fact, this case is remarkably similar, I think, to the Waterman case. Okay, so I've mentioned that case. And then I talk about the concept of joint ownership a little bit. I don't know whether this is what you'd be expecting, John. Yeah, sorry. Okay. I'd be looking at Waterman, Perito, that's how you pronounce it.
Actually, the Perito series of cases, that's another one I'd flag up as being very good to read, to get your head around.
So there are a number of those as well, aren't there?
Yeah, for several years. Although the appeal, I think that's the appeal case.
Yes, it is.
Yeah,
Yeah,
that's the most important one. But if you wanted to understand the background, there are some earlier cases which are available.
There's some quite interesting things, actually. I think now this comes out of Perito, or something completely bonkers. I think, or is it coming out of Waterman? No, I think actually what I'm about to say is Waterman. Where the court says that joint ownership, I like some of this, was not intended to be quantitative, but was qualitative as such. And also, I've got a sneaky feeling this was the case where, am I right to say, they criticised the English case law in this area? It is, isn't it? Yeah. And they said, well, the English got it in a right old mess, so we're not going to follow them. No, I'm pretty sure it's Waterman was the case where they were criticising the English cases. Well, we're certainly not going to follow English law because they can't get it right. So, you know, we're going to sort of look at it from our own perspective. So that was quite interesting. Also, and I think this was important, the court said that, and now on to Perito, that when we've got joint ownership, it is deemed to be equal between the parties. We start off from that particular perspective. But, correct me if I'm wrong, John, there are circumstances where that equal shares, I suppose, I don't like to call it that, can be rebutted. But I think it was the deputy bailiff, wasn't it? Didn't really go into the sorts of circumstances when that would occur. I mean, I presume if you put an express clause in the conveyance, you could do that, surely.
If the appeal level part of Waterman is a very good case to read, because that's Jersey's bailiff, Balash, Smith and Vaughan, good. If you went back and looked at the early decision of Chris Day, who was Deputy Bailiff at the time, Chris was faced with an almost Herculean task of trying to bring some kind of reasoned judgment to what were frankly some pretty poor submissions by counsel for both sides, which didn't help him in the slightest. So he was almost trying to write an academic textbook on, well, this is what the law is, because none of you, the advocates who came to my court, appear to know. And so you have to read what he says with a bit of reservation, because as the appeal court pointed out, he may not have got some of it quite right. But certainly, what the appeal court said was something that when it came out, practitioners said, yes, we recognise that, because that's what we've always thought it was, even though there's never been a case on it. So when it comes to co-ownership, as I say, you only need for the exam to know the sort of, the real basic understanding of the two principal types, joint and co-ownership, how you end it, some of the instances that happen then between co-owners, which is what this question is about. We certainly in practice use much more sophisticated vesting. And the key here is that you need to say whatever vesting you wish to have. So even if it's joint, you could express that it's joint with the survivor during your lifetimes with reversion to Fred as to 2/3, Mary as to 1/3. But you must put it in the appendix.
So you're actually
So you then create to your, sorry, repeat how you phrase that for us. So you do it as joint owners with the reversion. I thought when if you're joint owners, it just would not cancel survivorship. So
Only if you say that's what you want. So you will find
you've got to use words of limitation. Yes.
Yeah. So by way of example, there's a reference here to Kelly. He gave an example there of a vesting that was very commonly used in the 19th century. It's almost never used today. It was very common then that often the parties would declare that they held the property. I'm going to say it in French because it's the best way I can say it. It's pour eux le vivant des deux, et après leur décès, aux droits du mariage, procréé du mariage, et en faute aux droits du, and it would either be the husband or the wife. Very sophisticated vesting. So they're saying we buy jointly. If we have legitimate children, it's for the survivor of us and those heirs. If we do not have children, if it's a barren relationship, it goes to, and it can go entirely to one side. Now, we rarely use that in modern society, but it just is an example of sophistication that they started bringing in when this concept of using joint ownership became common in Guernsey. Now, if you were to read, and I accept that it's quite a long read, and some of it is quite hard to understand because of the language involved. If you read Peter Jeremy's evidence as a commissioner of Jersey at the 1861 inquiry, there are some absolute golden nuggets buried in there of what, certainly at that time, everyone understood ownership of property and sometimes even the vesting of property was involved with. The commissioners in that hearing were surprised that Guernsey had such a thing as joint and for survivor ownership. They put it to him as, do you have Motti and Motti? He said, no, we have it as joint. And he explained what they did. The commissioners then remarked, and he also commented that the Royal Court have upheld several cases, and he quoted one.
So I might be confused. I haven't had time to do all the reading because we only got them last week.
Yeah.
I thought that joint ownership was for survivor, so that if you have something in joint
Only if you
ownership,
say that is what you want.
Yeah.
but doesn't that? But then isn't that inconsistent with having? So if I said something different in the vesting clause, so I own it jointly. So I own it jointly with my husband. So there's no.
With reversion to your children.
But then what's the point of holding it jointly if it's not going to pass?
Because what he has effectively got is a joint ownership, which he must be a party to anything that happens with the house. You
That's
cannot.
fine whilst we both alive.
Correct.
Isn't it in effect, you sort of, isn't it almost like a usufruct?
Correct, yeah.
So that you're sort of making a usufruct of the joint. Sorry, I don't know how else to explain this. So you do things. You see, the difference is in England you use trusts for a lot of this, and you've got to just forget about all that nonsense and just think of it in a different way. Because I'm right in that you said this earlier. You don't use the trust that often, so therefore you've got to faff around with this. Is technical language. So you faff around with the ideas of co-ownership and usufruct to achieve what in England you'd be achieving with the trust. Am I? Yeah. So you can do all sorts of things, and you sort of combine them together.
Yeah.
I think then that I've understood it incorrectly. That actually doing ownership and the vesting
He does get it, but he only gets it. What you're doing, you're protecting interests, aren't you? For the family. So he does get it. But he only gets it for a limited period.
I understand that, but I just thought.
Oh, I see. Yeah. Oh, I see.
Differently, that seems totally inconsistent.
But I don't think it is inconsistent because it does accrue to him.
But you're saying it doesn't.
Yes, it does, and then it goes to the children, doesn't it?
It depends.
Well, if that's what you've just done.
Yes, in essence, what he's got, the correct, is that during their joint lives, as between the two of them, he can do nothing with the property without his consent. He can do nothing with her consent.
So you're reducing them to tenants for life in English phraseology. Yes, but don't use that phrase. But that's what you'd be doing in English terms.
Another way is saying, she is the holder of the new property area. What he's got, which is contingent upon or coterminous with her for his life, is effectively a usufruct, but with a bit more added to it.
I understand that bit. It's just the difference when you're vesting to something else is that seems.
Yeah.
It seems if, for example, if that's what I wanted, so straightforward, I own spouse, husband and wife, owners, joint owners, so there's no division of you have 50, or 70-30 as you would on undivided shares.
Yeah.
So when I die, or if I died, that it would pass to my spouse because I didn't want to do the undivided shares to pass to children from a former marriage, which would be the normal circumstances. So for joint owners, the normal vesting clause was for my survivor. I didn't realise that you could then do something different. So, and I wonder in what circumstances would you do that, because I can't think of.
To provide for the children.
When the client comes along and explains their circumstances and says, how can we address this?
But then would you not be better to hold in undivided shares because you can account for the wishes?
Well, it
I'm
depends.
making myself very clearly, but it just seems a bit odd that you can do something totally different on the vesting clause when I thought hold owners would have it. Is that not?
But it does pass to the spouse, doesn't it? Unless I'm
No.
well, not pass, but they get the use of it, doesn't
Well,
it?
yeah, precisely that until the time of death, they are an owner of an interest in that property.
But what I mean is that they can't do anything.
Without the consent of
with it. With
So instead of his wife, he now has her children. And they can't do anything without him either.
Yeah.
Well, in fact, they could sell the their ownership, but no one's going to pay very much for it
No.
because
he's still
Because he's
involved,
there.
because he's there.
Yeah.
Yeah.
So on your death, he gets life insurance.
If that's what it
yeah.
says in the reversion clause, because it just, yeah.
If it just says, or do you like to?
Yeah.
If you've just got a straightforward joint ownership, then
Yeah.
it just automatically accrues.
Yeah.
But you're sort of you're trying to find. I mean, you're trying to find very inventive ways, I suppose.
So he has done his own half interest.
So,
If you didn't want to have it all going to her children, the example I've cooked up, then yes, the alternative way would be to say to them in that case, you are better each holding an undivided share for your co-owners rather than joint owners in your respective proportions, with a usufruct for the survivor over the other's share.
No, I'm just surprised. My understanding was that joint owners, the reversion would be for the surviving spouse.
It is not
Solely, yeah.
it's not sort of
I've been miseducated on that in the past.
if you think there's
Yeah.
actually just
Yeah.
ways you can do it,
Yeah.
lots of them.
Yeah.
That's why I said I was going to bring examples of some of the things that we do,
Yeah.
and I decided not to because
interesting.
it would have kind of perhaps confused you further.
I mean, for what we need to understand, is it more usual? The basic concept is that the joint owners, it's usually the survivor, but there is a way of doing the reversionary interest as something different.
Yeah,
the right one.
You will discover
Do-
this is the very kind of problem that is called.
yes, it is.
How do you do the fun?
Yes, I think you do need to know what John has just said, because I've gone through this past. I haven't gone through them all because I don't have time to go through, but this sort of question does arise, and how do you solve it? So yeah, I think you do need to know that.
There is.
Obviously, it does.
I mean, I maybe need to look at this when I've read the book.
Yeah, it does pop. It does
It's
pop
not
up.
in my head.
No, it does pop up
My
on the paper.
understanding is joint survivors, joint owners, passes on to
It does in English law, but it does.
No, in Guernsey law as well.
Only if you say that's what you want.
In the conveyance.
Ownership, remember, ownership in Guernsey, the concept of ownership is all about holding for an estate of inheritance.
Yeah.
That's the real key. Our ancestors would have been amazed that we trade property as an asset. Unheard of. They had the sole concept of holding it for family forever.
Yeah.
That's all they ever thought about. That's why succession is so important. That's why so many of the rules revolve around succession. So the important thing is to declare who ultimately it's going to go to. So what
So this is probably where I'm sort of maybe confusing, is that the joint ownership you're thinking about in their lifetime. So at that point, I couldn't go off and try and sell it without my joint owner's consent.
Correct.
But on
Correct.
death, the reversion can be dealt with slightly differently.
English law, if I can use a bad analogy, would probably look at this and say, oh, you're creating a fee tail,
Yeah.
limited for life. So you have the fee simple, perpetual, the fee tail, it's tail stopped.
Yeah.
So it's down to a limited period, his life.
But can I just ask, so in undivided shares, I think my education probably got amazing. With undivided shares, then, I thought you usually use the undivided shares. the situation that we've just been discussing. But in your lifetime, if you're holding it in undivided shares, could you then go off and sell your share?
Theoretically, yes.
Yes,
But
yeah.
practically, no. But
Practically,
theoretically,
yes, which is another reason why you have to say to people, you could do it this way, here's the compromise, which one can you do?
Because if you held it in undivided shares, I could go off and sell my half of the property to somebody that you hate.
Correct.
But practically, what they're going to pay for it.
yeah.
Yeah.
Correct.
But it's theoretically possible, yeah.
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 Do you need the consent of the other co-owner to sell your share? In
If
those
it's
circumstances?
undivided, no.
Undivided, no. I think that's probably, I hadn't appreciated I just thought joint owners, the reversionaries for the survivor, that's it. There wasn't the option to leave the reversionary title to in another form.
Mm.
Yeah.
Yeah,
Maybe we're going to look at the exam papers and a bit more gender, but all there.
yeah. I use the word reversion in our ordinary sense of the meaning. I think in the English
No.
concept of reversion. Perhaps I was
No, you mean it's what's in the conveyance?
Yeah, what I'm really talking about is new propriety, the fair ownership. That's the principle we hold in our head. Fair ownership.
Yeah, the bit that when I give this conveyance, blah, blah, blah.
So when you convey concept of inheritance, it's fair ownership we're dealing with. Because we don't, again, have the notion in our law of legal ownership and beneficial ownership. They simply don't exist. Which is why trusts are such a hard thing for us to accept, because that carries with it absolutely the idea of beneficial ownership. And equitable interest and things we just do not have. So there is a sophisticated way of dealing with ownership, but not using trust.
Yeah.
So as Merrill is saying, that's a hard thing if you've been given English law background teaching. You've got to kind of abandon it.
It's much easier if you come from a civil law
If like me,
isn't it?
you started in a Guernsey law firm, and when you encountered English common law, you thought, what the hell? You guys are bonkers. So I go off to France again in court, and I'm thinking, it all makes perfect sense. Everyone around me who was English law trained was freaking out. They're very different systems.
It's so wrong. If you go far enough back in English law, it becomes it becomes more like
Yes,
the law of Normandy.
very much so.
Yeah, so it's quite bizarre.
And why they went off in the direction they went off.
Oh, I could bore you with that one, but I won't.
It's probably all that latent Anglo-Saxon seems to have written.
Oh, I don't know. Do you think so?
It's got something to do with it.
I don't know. Yeah, you could be right, but yeah. Okay, let's get back to this one. I can't remember what I was saying now. Oh, I think I said that. Did I say presumption? It was equal unless the conveyance says something else. Did I say that? I did say something
exactly,
like that, didn't I?
that is
It was
law.
that was sort of, I think. That's what. So
where we got to.
that's where we got to. And that's,
We said it's presumptionless stated.
that's right.
And that's where we had that discussion. You can state that it is unequal.
That's right. So it looks to me on this conveyance, I could be wrong, it looks as though it's a straightforward joint ownership. Would you agree with me?
Looks like it.
Yeah, it looks like it to me. I don't think anything fancy has been done there at all. So it's sort of Heidi as you believe it to be, so to speak, as you understand it to be.
I think I've just confused myself.
Yeah, no, I mean that one is a straightforward sort of joint ownership thing. She wants to know whether she can bring this arrangement to an end. Okay, and now I think I'd start discussing other points that you might have mentioned earlier. So, yeah, this is where I start. But I do all that stuff first and then come on to this, I must confess. Otherwise, I think you're going to lose marks. And we were talking a bit earlier about sort of the mathematical approach to these questions, that there's a structure to them, that you've got to sort of discuss what the nature of this, these interests are. before we get on to can she actually terminate it or what can she do about this. Okay. There are two things, I suppose. Well, let's think about it. Is she going to want to use severance at all here? Does that make sense? The question.
Sorry, what's this French maxim? I don't know.
Hold on, I haven't got onto that yet. Hold on. I just want to have a look at severance a second, because you can sever joint ownership. So is she going to sort of try and sever here at all and convert it into common? Or is she going to try for someone else? If she severs, she can sever, but if she severs, what's that going to do? Yeah, it's going to give him something, isn't it? Yeah, I would agree. Then I'd go on to the nullne tenu, the reste, etc. So nobody can be forced to remain in a state of co-ownership. So what is she going to try and do here? She's got various sort of, what do you call them, remedies? I don't know whether I call them remedies or actions. Actions.
Ultimately, she has one action, but she starts out seeking an alternative remedy.
Oh, right. Okay. Right. Okie dokie. Thank you. Right. What's she going to try for? What's she going to do with all this? Oh. Okay. Let's have a look at. Sorry, you haven't had a great deal of time. I know this, ladies. There are three things she can do. Well, I don't know whether that's the right way of putting it. We've got délaissance, we've got partage, and we've got licitation. Would you all agree with that?
Mutual agreement.
Yeah. Yes. I think. Yeah. Right. Let's go through these. So look at délaissance first of all. She's gonna what? Yeah, I think that's the problem there. Now, I don't know whether he's going to agree to this or not. If I were him, I wouldn't, but you know. So that's the big problem that we've got. It's where really he's going to have to renounce his any interest he's got, or any rights, or I should say, any interest that he's got. It is a form of conveyance if he agrees to this, but you're absolutely right, he's going to agree to it. So I don't know what else I can say about that, really.
So in case there's a mutual agreement, presumably there'd be a scrap about you get what, but he would say I get 50-50.
No. I don't think that's what I'm saying. This is a renunciation. Of his interests. So I think if Mary were trying to get him to délaissance, I'm not sure that's yeah, I am. Then really what she's trying to claim there, I suppose, or trying to argue, is that she's got it all, and he's saying yes, ma'am, you've got it all. Well, I don't think so. Yes. Yeah, we'll come on to that in a minute, I think. Yeah, all right. So I don't know if he's not going to agree to that. Oh gosh, what about partage? Sorry, yeah. What are you going to say about this? Yeah, I mean, this does actually mean a physical division as such, so you've got to be able to physically divide. And again, I'm not sure this is achieving what she wants it to achieve. Because I think what she wants out of all this is she wants all her money back, doesn't she? That would be my guess. What do you think?
Well, yes.
You know, that does seem to be what she wants. And then, licitation. Can she use that?
It's from the Latin, put to the same.
Yeah, he's going to refuse to sell, and partage doesn't work, so they can go to judicial auction. But it's not common because of the incident.
It's not common in practice because then people are confronted with the awful reality of what could happen. They lose control of the whole process. Someone could walk in and say, I'm going to offer £10.
Yeah.
And they are compelled to sell to him.
Am I right in saying that that she's going to have to sever before she. I don't think she's going to use.
No, there's no separate in my view.
Is there not? But I thought you had to be in common before you could use it rather than joint.
No.
That's just Potier, is it?
Licitatia is available for all persons in ownership. So if you own anything, whether it's co-owner or joint owner.
Oh, I thought it was only in common. Right, okay, that's my mistake. Sorry.
So you
That's
do-
my
you would
misreading
follow,
of
you would
Potier.
follow the same principle in joint ownership. And
Okay.
certainly the very few cases, and they are listed here, Boogle and Woodhead, Greening and Zavala, Boutellier versus Delisle and Richards, of course, that's historically fascinating because it's how Guernsey's commercial arcade came into being. That is the case between the developers of the commercial arcade who fell out.
Which one? Boutellier?
Boutellier and Delisle and Richards. They built most of the commercial arcade. They hadn't quite finished all of it, but they built most of it. Fell out spectacularly. Couldn't agree between them what to do.
In 1832.
In 1850. And it went all the way to the Privy Council, who ordered a partage. You will find the partage in the Gref records in 1832. And a fascinating document it is too.
Is that because it was commercial premises and you could divide them?
No, it was simply it was decided that
In terms of the parcel.
as owners in common, the first thing was, can we partage the property? Of course we can. It's a parade of shops.
Yeah, yeah.
Yeah.
Yeah, so you take 5, you take
You
5.
can take those, I'll take this one.
Yeah. Whereas partage isn't really appropriate for
For the
residential.
vast majority of properties, it's not relevant.
I guess if you have like an outhouse, the dower.
If you genuinely had two separately habitable units, yes, you could partage.
Yeah.
But the court won't, the jurors will not find, as a matter of fact, that you can partage if you have, even if it's a big house, but you'd have to spend, £120,000 divided into two.
Yeah.
That's
So, well, I don't know what our advice here. We're not succeeding in helping Mary here very much, are we?
no, she
She wasn't really wise.
No, she was
Right at the outset,
stupid. She was stupid, wasn't she? Would our answer be any different? Well, I can't see what else we can do.
Yeah.
And unless Fred yes, it is Fred, agrees to.
I mean, that would be the practical example, is that you settle by mutual agreement and pay him the sum. That's practical.
Well, either they would have had to, this relates back to our previous discussion about investing. If they had good advice at the start, but they might have ignored it and decided to do this anyway. But the advice at the start would have been, well, Mary, if it's your money, it should be your house. That's the brutal bottom line. If Fred is nervous that you might throw him out, then we can, gloss the joint ownership so that it's joint, but it all reverts back to you. So the real bare ownership still belongs to you. However, it does mean, and a good advocate would have spotted this and said, it does mean that if Fred takes up with a lap dancer, sorry, what a joke, he could move her in and there's nothing you can do. Because that's, even with co-ownership, not any different. The moment you enter into ownership with another human being, you're reposing an awful lot of trust in them in terms of your living arrangements. That's the bottom line.
So if they're living, it doesn't say whether she's living with him, does it?
Then you wanted her to live.
Sorry, no, Mary's living with them.
Well, it does say at the beginning that she can't afford to buy anything else, so it looks as though they're all there together.
So they're all there together.
Yeah, they're all there together.
Yes.
Happy little family. And then,
Sorry, they didn't do it.
yeah,
So that's the one of the downsides, is that she can't prevent him on.
I'll see what she can do.
So the only protection she could ever have had, sole owner,
Yeah,
full stop.
yeah. I agree. And what about the side agreement, I think, which is the next bit? Waterman sort of leaves it open, doesn't it? But I think it's accepted that possibly there something could be done. I don't know if you agree with that.
You certainly have a couple of different approaches. Some advocates, as we mentioned in the guide, will insert provisions into the conveyance that attempt to detail what happens to the sale proceeds, what the parties can and cannot do during their joint ownership. I personally am rather sceptical about what that achieves. Because unless you put it in the addendum, you've got no remedies. What are you trying to enforce?
But if you put it, I thought you could put it in the addendum.
You can put it in the addendum, but they never do.
Oh,
It just appears as a series of clauses later on in the
oh, and then I thought that you could. I didn't necessarily think it gave you any sort of real property rights. I thought it did quite some persona.
Well, if you put it in the addendum, it gives you real property
Would it give you real property rights?
because,
Okay.
because you're trying to play with the best. The problem is when they start talking about, you shall not allow anyone else to live in the house. That doesn't belong in the addendum. I don't know how that's enforceable.
Yeah. Okay.
So in practice, what you tend to then end up doing
Put it at the end.
is having side agreements.
Yeah. Yeah.
That gives you rights and persona,
Yeah.
particularly with regards to self-hosting. Because then that just becomes claimable as a contract.
Yes.
You owe me this money.
They are committed, they are committed.
The court left it simply open and said, we are not saying that you cannot make these arrangements. But they did say if they are to be legally enforceable, they should be in the addendum, the vesting.
So.
And they could be registered.
Oh, well, obviously.
Yeah. Oh,
it
I
should be
think. Yeah.
registered.
Sorry. Yeah.
The addendum is the vesting clause.
Yeah, it's the bit after the opening parties where you've got parties are named. As
Yeah. We'll come on
vendor.
to this.
It says witnesses, vendor hereby conveys to the purchaser. That's
So
the
you're
vendor.
saying with the side letter is that the legal interest doesn't change, it's just what you so if you have
Gives you a
in
remedy.
that example, Fred still has the legal interest, and in theory the proceeds of sale should be split as per the legal interest.
Yeah.
But if he doesn't honour the signed agreement, Mary has a right to pursue him under that side agreement
Yes.
contract.
Yeah.
Like a cohabitation agreement or something.
Yeah.
Yeah. But it doesn't affect the principle of the legal side.
Correct.
But in effect, the house is going to have to be sold, isn't it?
Yeah.
To honour the agreement.
Yeah. It's
So
a way almost of achieving the licit hassle without involving the court. It's a private means of getting to the same end.
Then you'd still have to force the sale.
Correct.
Yeah.
Now, the way that is often dealt with in practice is that each owner within the cohabitational agreement will grant to the other a power of attorney solely connected with the contents of that agreement.
So you can give the title to the.
So it's a special power of attorney, but solely for the purpose of achieving a sale in connection with the agreement.
But does that mean that
I mean, is
one
this
need
going
not
on?
know that they've actually necessarily fallen out and that's the
Uh,
You could go off on holiday and all of a sudden choose to use the power of attorney.
Theoretically, that could happen. Yeah, I think the purchasing advocate would want to see a little. You want to see, well, why are you using the power of attorney? Where is your co-owner?
That would come from your search.
It would come. Well, yeah, because when you go on site, you straight away be saying, well, where's your co-owner?
Yeah, you'd be invested.
Because they're expressly shown as the property.
I guess it works if you've got the going. Gonna run it.
That is exactly the reason we do it that way, because we had a case like that many years ago where the co-owner, they've done the agreement. The co-owner, they fell out, the relationship ended. The co-owner moved to Australia.
Yeah.
It took us 3 years to track her down. And then we had to persuade her to sign a power of attorney in Australia. Not a perfect solution. No solution is perfect. It's a solution.
It's like, because in England you get around the court order to give the title on that. So as a purchaser, I'd be interested that I've been given that I've got a good title. So
But you've got overreaching machinery working in England, which you haven't got, so you can't sort of, no. Because that would all go behind a trust anyway, so therefore you'd be using, so can I tell you something, ladies? If you can possibly forget English land law, no, I don't mean this rudely, I think it'll make life a lot easier for you. Do you agree with me? It's a bit sticky. Yeah, because I always find that I just forget about English. Some of the history stuff is actually useful because you can draw comparisons with civil law and Guernsey law and some historical concepts. But modern day land law, I would just forget about it in England because I think it makes life a lot easier for you if you just don't try and sort of go, oh yeah, this is like da-da-da in England.
So where's the Guernsey equivalent?
Yeah, because I think,
then you're going to fall in a big hole.
but I don't necessarily have a problem if you go, oh, where's the French equivalent? I mean, you might have a problem with that, but I don't necessarily think that's so problematic because it's French. So if you know French property law, I don't know whether you do. Oh, right, then forget that comment. Okay, that's completely rubbish.
Have English to compare it to.
Okay. No, don't compare it to English property law. You can compare it to French. I think it's a bit easier, although sometimes I even get that wrong because there's things that happen in France that don't happen in Guernsey, as John pointed out to me. Yes, it has been slightly different, but it's nearer. You know, you can look for things there and say, oh yes. But I don't think you can with English law. I don't think you ought to be looking to English law to find some comparisons. I think you're going to get very confused if you do that. But I agree with you, it's very sticky. Okay, I think there may be some.
So basically, as long as you run through the forms of severance, but there isn't really.
Well, I don't think there's a.
I was going to say, be careful. That's this notion of severance in English.
Yeah.
We don't have.
I mean, it's a way to terminate the ownership.
In English law for severance, you just write a letter to your co-owner.
Oh, yes. Yes. No, you can't do that. No, you can't do that. No. And we may well be coming back to some other questions on this because they do pop up from time to time on the paper. So I think it's worth having a look at that area in some detail. Okay.
John, do you think it's a good time to go through some of this stuff?
Oh, crumbs, is it that time? Yes, so we did go 2.5 hours last week. Now, come on, yeah, we did. No, yeah.
What time did we break for lunch?
We will break for lunch at 1 o'clock, get most of the work done this morning. You know how I feel about that. And we had half an hour lunch break, didn't we? Are you all right? Sorry, I sort of didn't ask you in advance. I just gave you a fait accompli. Half an hour, all right with you ladies as well? Because then, okie dokie, and then we'll go on to a 4. John won't be here for the last hour, so you've got me. So don't ask me any nasty questions. And we will do immovable property. I ain't going to do any conveyancing without John by my side, holding my hand. All right, let's go and get a cup of tea or coffee, shall we? Certainly some coffee in life. I think I've got to pause this thing again. Oh God, I don't like doing this.